The next case to come before the court is State of Ohio versus Jerold R. Potts. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know as I'll be keeping track of time. The arguments are being recorded, so please keep your voices up and remain behind the podium. You should not use the names of children or minors and victims during your argument. You may use general terms or initials. The judges have read your briefs and are ready to proceed when you are, and I would just ask at this time whether the appellant would like to reserve time for rebuttal.
Yes, Your Honor, 5 minutes, please.
Very well. Then you may proceed when you are ready.
Good afternoon or good morning, Your Honor. This case involves a felonious assault charge that my client here was convicted of. The first issue I have that I argue in this case was whether or not there was a question of sufficiency in this case. The victim in this case, who is his sister, testified that she was not injured by him when this occurred. She testified that she did not see him do this. She testified that she was unaware of how this happened. She indicated that, frankly, that it could have been done by her when her back was turned or something of that nature. That's one of the issues in this case, Your Honor, is sufficiency of evidence, because the victim, the main victim, under oath when she was in this case, said that didn't happen, that he didn't do it. And in fact, the state used evidence on this case, a statement that the victim gave, and that statement, the victim indicated that, hey, I'm not going to back that statement. I'm not going to talk about that statement. I'm not going to comment on that statement. That statement is not true. So she indicated in her testimony under oath that the statement that she gave to the police was not true. And then, so in terms of sufficiency questions, there is no way that there should have been sufficient evidence that this case was found guilty verdict of my client. With respect to manifest weight, the same issue. But it's more, because when you're looking at situations where the victim testified, again, she's indicating that it wasn't, that she did not see my client do this. She suggested that my client may have been frustrated and upset and smashed the pan against a table or something of that nature. But she totally indicated under oath that this did not occur. She did not see him do this. And that's the thing. It's under oath. So when she gave the statement to the cops, it wasn't under oath. But when she came to the court, testified under oath, that's how she testified to. The other witness in this case, who was her sister, the daughter, Spree, I'll just call her Spree, she indicated that she did not see Jerold Potts strike the victim in this case. So there's no evidence that anything, that my client did anything that was proved beyond a reasonable doubt. The other issue in this case is that, as the court knows, my client represented himself in this case, and there was never a signed waiver of counsel by my client. And if you look at the colloquy that occurred in this case, where they went through the colloquy in terms of waiving the rights in this case, my client was not advised that he was going to be held to the same standard. And so I believe that the waiver, the allowance to let my client represent himself in this case was improper. Another issue, Your Honor, is that my client received 3 to 4.5 years in this case and has no record. No record. And it is clear that the victim in this case did not want my client to go to prison. And there was absolutely no reason to send my client to prison at all in this case. Finally, there's one more issue I'd like to speak about, is that during the trial, my client was removed from the courtroom. And not only was he removed from the courtroom, he was taken to the jail and on video. So basically, they tried a jury trial of my client on the video. And what that, I believe, and the record suggests that they muted my client. So in terms of being able to speak, or it's being able to communicate during this trial, my client was muted at the jail by the court. And I believe that's improper. So for all those reasons, I believe this verdict should be overturned.
Counsel, what should the court have done in regard to, I know one of your main arguments is what you just said, that the defendant was removed from the courtroom. He had standby counsel, and then he was given the opportunity at least to see the proceedings and so forth.
Yeah.
He was being disruptive. He was yelling vulgar things. He was constantly questioning the jurisdiction of the court in front of the jury. What is the judge supposed to do in those circumstances?
Your Honor, I think this was an overreaction, because what happened was my client was muted. I think it's a little bit of a different situation if the defendant is able to speak, is able to have conversations. There was a standby counsel there, that's true, but my client was muted. So when you're talking about the opportunity to have communications, to do whatever, and the other thing about this case, and not only was he representing himself, he was basically his own witness, and he didn't testify, but see, that's the thing, is that any credibility issues with respect to him would have been questioned and by the court removing, because when the court removes a person and makes a statement in terms of credibility, in terms of truthfulness, and credibility as to weight of substance of testimony, that's when you get into trouble. And in this case, I believe that the court overreacted.
Counsel, I want to go back to your comments about the inadequacy of the colloquy. Can you expand on that for me a little bit? Only what's in the record?
Yes, Your Honor. Well, when I reviewed the record, I saw that there was some issues with respect to the colloquy. When I saw there was
And specifically, what were
a
they?
lack of a description in terms of what was a potential, I have it down here, what potentially could be, in terms of that person being held to the same standard as defendant. And that, the issue that I saw with respect, and where I really have an issue with it, is with respect to presenting evidence. In this case, and why there was no evidence presented by defense in this case, and the reason is because I believe this guy was ineffective, could not represent himself. There's witnesses that his sister put into record prior to trial, people who were supposed to come in and testify. Nobody was called as a witness for him. So.
But he had standby counsel too, right?
Yes, he did. Yes, he did. But,
Okay.
all right, thank you. I appreciate
Well,
it.
thank you. You will have your full 5 minutes on rebuttal.
Thank you.
Thank you.
Good afternoon, now, Your Honors, and may it please the Court, I'm Vince Felucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. I'll begin with the sufficiency and manifest weight arguments, and I'm going to, it's kind of difficult, but I'm going to call the first victim SM and the second victim SM2. They both have SM initials. So SM is the mother and SM2 is the daughter. So SM changed her story at trial completely from what her contemporaneous statement on the night of the incident. In a fairly transparent attempt to protect her brother. As the jury had the right to do, they chose to believe her contemporaneous statement from the night of the incident, which I'd like to read some of. I hesitate to read all of it, but it was very compelling, and it is in the record and in evidence in this case. Around 2 p.m. on Sunday, November 22nd, I asked my brother, Jerry Potts, if he would assist in bringing a piece of furniture into the house. He became angry and said I didn't have his permission. I told him I didn't need his permission. He then went back upstairs and came back down again and said he was making his tea. He then took the wet tea bags and threw them at me and onto the floor. because I had moved the garbage can out of the mudroom to make room for the entertainment center. I picked the tea bags up and threw them back at him. He moved towards me in a threatening manner. He raised his fist to hit me a few times and then stopped and picked up the pan he made his tea in, raised the pan a few times to strike, and I told him, "Don't do it." I didn't think he would do it, so I let my guard down, and he struck me to the left temple with the 12-inch stainless steel frying pan. I called out to my daughter to call the police. When she came into the room, he started grabbing her and told her to get out of the house. He then grabbed her by her feet and drug her out of the front door. I went outside to help. He slammed the door and locked us out. My daughter called 911 and we waited for medical and law enforcement. Now, the testimony of SM2, daughter, never changed. It was also very compelling. She testified that, to essentially the same facts here, that they bought an entertainment center. Her mother went inside the house to ask Potts about helping bring the entertainment stand in. Mr. Potts then came out in a huff, grumbling about SM2 even being at the house. SM2 testified that she went to the bathroom and a couple minutes later heard her mom yell out, "SM2, call the police, call the police, call the police." SM2 comes out of the bathroom, sees her mom hunched in the kitchen with blood coming out of her forehead. When SM2 admonished Potts, Potts grabbed her by the arms, telling her to get the F out of his house, dragging her out of the house, ultimately dragged her by her ankles, or initially had her by the arms and ultimately dragged her by the ankles out of the house, shut the door on both SM and SM2, who were then waiting outside after SM2 calls the police, waiting for the police to get there. SM2 noted that Potts was angry during this whole event, and he had been angry for quite some time. In the days that followed, SM and SM2 actually both looked for the pot, or the frying pan that Potts hit SM with. They found it in pieces, so it actually broke. That's how hard he hit her with it. It was in two pieces. They found a handle in one place in the house, which was actually in Potts's room in a trash can, and they found the rest of the broad part of the pan in an attic crawl space. And law enforcement also corroborated both SM and SM2's testimony in terms of what they observed when they arrived at the house. You had Officer Singleton, who saw SM and SM2 both outside and saw SM with her side of her head, a laceration, so it's bleeding and it's all over her forehead and her hands. Scratches all over SM2's back, which SM2 said were from her being dragged out of the house. Officer Singleton noted that SM and SM2 were more than willing to write statements of their own free will on the night that this happened. Noted that both accepted temporary protection orders on the night that this happened. Potts did not respond to Officer Singleton's calls over the PA to come outside and surrender, so ultimately they had to clear the whole house and had to arrest him upstairs in the attic. That's just the beginning of Potts's being difficult in this case, to say the least. Then you have a trial. I'll move on to the waiver of counsel. This was classic invited error and classic substantial compliance by the trial court, who did everything that it could and acted throughout this trial with the utmost professionalism in the wake of somebody being extremely difficult. And I think the transcript will quickly reveal that when you look through it. Potts made it abundantly clear that he wanted to represent himself in this case. But at the same
The
time...
question I have, though, counsel, is did the court do what it needed to do to engage the defendant?
Yes, Your Honor. And in fact, I would say went above and beyond in terms of everything that happened on the record. It's several pages. I want to make sure I don't miss anything, but the online docket actually shows that a written waiver of counsel was prepared for him, but he refused to actually sign it. A notation on the online docket that you can see will state, quote, "Defendant refused to sign. Judge elected not to sign, but still asked the document to be docketed." Essentially, him not signing was for the sake of being difficult. He clearly wanted to represent himself. There was no question on the record, and they went around and around about this. First, you mentioned the standby counsel, who remained in the courtroom throughout the trial, was available to answer any of Mr. Potts' questions. The trial court correctly recited the charges and all of the possible penalties. The trial court defined all the key terms in Potts' charges: knowingly, cause, serious physical harm, deadly weapon, all those kinds of things. The trial court informed Potts about the 2 counts of felonious assault potentially being allied offenses of similar import, so he might only be sentenced to one of them. Explained that there was a non-mandatory presumption of prison if he was convicted of these charges. Explained post-release control. Explained all of the possible defenses that Potts had to these charges. The trial court strongly encouraged Potts to have an attorney and not to represent himself. Certainly admonished him on that. Trial court had the state of Ohio place its plea offer on the record, which Potts rejected.
Counsel, the one thing that he is saying that the court didn't do is tell Mr. Potts that he would be held to the same standard as a fully licensed attorney.
And I don't know that he said it in those exact terms. That may be true, but I think he did go above and beyond given the totality of everything that he told him. I don't think that particular phrase is something that's required in any event, but he told him about lesser included offenses within felonious assault. Essentially, all of the law on this was very thoroughly explained. Even answered a few questions that Potts had. So, and then moving on to the commitment of Mr. Potts to the jail during the trial, which, and then they allowed him to contemporaneously participate through a video feed, which frankly the trial court did not even have to do that. Under Criminal Rule 43B, Potts is that kind of behavior is exactly what 43B is designed to remedy. If you look at certainly pages 318 through 323 of the transcript, that's where ultimately he was made to leave the courtroom and taken to the jail. That exchange culminated in Potts calling the trial court an MFer. I won't say the actual word, and that's the point that he was removed. 43B actually gives trial courts the option to proceed with the trial without the defendant entirely. And so it could have done that, and would have been well within its right to do so. However, I think in an abundance of caution and patience, the trial court allowed Mr. Potts to continue to participate remotely from the jail. So certainly that did not violate.
Counsel, I'm sorry for interrupting you, but I was thinking with Criminal Rule 43B, the assumption there is the defendant is there as the defendant and has duly appointed counsel to represent him. Does that change the fact here that he was representing himself? Does 43B apply in those circumstances?
Yes, I think it does, and I think that's probably a big part of why the trial court did allow him, obviously, to continue, because he wouldn't have been able to, there wouldn't have been a case to put on at all if there had been nobody at the defendant's table. That's probably why the court did allow that.
Has that issue been addressed by the courts?
Your Honor, I'm not sure if that exact situation has, but I think if you look at the record, he had, Mr. Potts had more than adequate due process, was not restricted in any way. Nothing really changed in terms of what he could or couldn't do with the video link from the jail. He was still able to participate, and in fact did participate in the trial.
Was he able to, they said it was muted, so was he able to ask questions?
Yes.
So he was unmuted at times?
Yes. terms of the sentence, it was not excessive. In fact, it was only one year longer than the minimum, 2 years. He was given 3 to 4.5 years. The most he could have gotten was 8 years. So more than, he's still not even half is what he received of what he could have received. Potts has never admitted or acknowledged what the evidence overwhelmingly demonstrated that he did. He's shown zero remorse. His relationship with the victim clearly facilitated the offense. If you look at the recidivism factors, Potts incredibly even told the trial court at sentencing that he didn't want to be placed on probation because he wasn't going to comply with it. The underlying felony 2, felonious assault, violent crime, along with the seriousness and recidivism factors, gave the trial court plenty of reasons to give Potts more than the minimum. There's no indication in the record at all that the trial court improperly considered Potts' outbursts throughout the trial as a reason to increase his sentence. There's absolutely no evidence of that at all. That just did not happen.
I have a question. Video court is new, mostly new because of the pandemic. And so do you think there's any duty of the trial judge if he puts the pro se defendant who's representing a pro se defendant via video to ask questions, that he also has to make allowances for him to make objections as well as counsel? Did that happen?
I believe so. I believe he had.
Like if he had an objection and he was muted, was there some type of procedure for him to be able to do that? Because, if you take, I guess under the rule, if you took the person away, they're obviously not able to represent themselves, but once you put them on video, are you giving them the full ability to represent themselves?
I think so, because I think he could still object.
In some form, like
And-
raising his hand on Zoom or something?
I believe so. I think if you look at the record, he had the same opportunities I think he would have had he been president of the courtroom, Your Honor. I'm just going to wrap up then. If there are no other questions, I would respectfully ask the court to affirm the judgment of the trial court. Thank you.
Thank you.
Thank you. Just very briefly, just want to indicate that I did go through this colloquy again. I don't see anything with respect to them, Judge Collier explaining to my client what it means to be the effect, and he's going to be held the same standard as another trial counsel, which I think is one of the main issues when you do a waiver. So with that, thank you very much.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. The court is now adjourned.